to Crime and Court. My name is Heather, and this is a stream about the West Memphis 3. In fact, it specifically, as you can see from the thumbnail, it is about the Innocence Project's Amicus brief. We are going to read through that Amicus brief to clear Damien Echols of the crimes that he was charged of. And very quickly, I'm going to play this clip for you from ABC News, and they explain the case and the whole legal proceedings that have happened up until this, well, not all of it, but they talk about, some of their struggles with appealing and whatnot. So, what was I going to say? I'll interrupt a few times and tell you what's going on. So, yeah, I totally forgot what I was going to say. Anyway.
DNA evidence and Johnny Depp, the three convicts you're about to meet, had both on their side, and that proved to be
That's what I was going to say. This, I wanted to prep you that this video is actually 12 years old. So this video was created 12 years ago, and the three of them are still fighting to clear their names. So I just want to put that out there.
Enough to set them.
And they reference dates in here. So when they do, just add 12 years in your head to it.
Free from prison today, but 18 years ago, when they were rebel teens in their town accused of a gruesome satanic murder of 3 young boys, DNA tests weren't available and there were no celebrities around to take up their cause. Here's our Jim Avila for our series, Crime and Punishment.
It's a case so stunning, so controversial, it became a major cause celeb, with actors and musicians like Johnny Depp, the Dixie Chicks' Natalie Maines, and Pearl Jam's Eddie Vedder.
I'm also here to show my support for the West Memphis 3.
Speaking out for the defendants, 3 little Cub Scouts, hogtied and left in an Arkansas.
So these are the victims in the case. The 3 of them were found, as he just said, hogtied and nude, and badly hurt. I mean, they were no longer alive, but they had sustained injuries prior to losing their lives, most likely. So,
Ditch, and 3 teenagers enamored with satanic rituals arrested. It made headlines all over the country, even becoming the subject of 3 HBO documentaries called.
And I've talked about this in the stream that I did. I did a breaking news stream, and we're gonna. Well, that's kind of what that stream led to this. So, breaking recently, the Supreme Court is now allowing DNA testing in this case to help exonerate Damien Echols. We're reading that amicus brief that was sent to the Supreme Court in this stream, and then I'm going to read in another one the reply from the Supreme Court and why they chose to overturn. Because they had been trying to get this DNA tested for a while, and this is present day that I'm talking about. In this video, like I said, it's 12 years ago. So they've still been trying to clear their names this whole time, and it's just awful. And you got to remember, this was a time, 1990s, when, oh gosh, we didn't have anything. We didn't have internet. We knew nothing back then, and the world was not at our fingertips like it is now. We couldn't, you couldn't communicate with people like you could. Like, our world was so different growing up than what the kids have today. But I feel like an old person now talking like, when I was your age. But really, it was a different world, because we didn't have the internet and the technology that we have today at every individual's fingertips. We had technology, but we didn't have it to the extent it is today. Anyways, sorry, I didn't mean to get on a rant about growing up in the 90s.
Paradise Lost.
We were like really the obvious choice because we stood out.
And did I mention satanic panic? That was the whole point that I mentioned. Satanic panic was because, I'll rewind this a little bit, but that's the whole point, was because that they zeroed in on these 3 guys were because they wore black t-shirts with like heavy metal bands. And look at his hair is long. Oh my gosh, he must be a devil worshiper. So, you know, that's basically how these kids got. I mean, they're kids. He was 16, I believe, at the time. I can't remember all my details. I will do a deep dive into this case in the future, but I wanted to read these current filings just to see what's going on in the case, because it's fascinating. We have technology now where we can extract DNA and use it and determine if someone is or isn't part of a crime. Anyways, I'm going to rewind a little bit because I've been talking so much. So let me go back to here.
The defendants, 3 little Cub Scouts, hog-tied and left in an Arkansas ditch, and 3 teenagers, enamored with satanic rituals, arrested. It made headlines all over the country.
You hear how they said enamored with satanic rituals? Who said that? None of them are enamored with satanic rituals. That has never come into play. But that's the story, that's the narrative that the media portrayed them as. And because of that, because of the hype of satanic panic, these kids had no chance whatsoever.
Even becoming the subject of 3 HBO documentaries called Paradise Lost.
We were like really the obvious choice because we stood out.
I didn't kill these 3 little boys.
The celebrities fighting for the teens' release claimed the kids were railroaded because of their mullets, dark clothes, and fascination with the occult.
It makes me scared that, this could happen to any of us.
And it did happen to these 3 young outcasts, who came to be known as the West Memphis 3 after their hometown along the Arkansas-Tennessee border. Damien Echols, Jesse Miskelly, and Jason Baldwin, teenagers then, in their mid-30s today. Convicted in what many labeled a literal witch hunt. No physical evidence against them, imprisoned for nearly 2 decades.
I'm just tired. This has been going on for over 18 years.
In the beginning, we told nothing but the truth that we were innocent, and they sent us to prison for the rest of our lives.
Earlier today, there was Damien Echols.
But today, a bizarre final chapter with a stunning reversal. 4 years after ABC News first broke word of DNA evidence that could exonerate them, the West Memphis 3 walked free.
The legal tangle that has become known as the West Memphis 3 case is now finished.
Does anyone believe that if the state had even the slightest continuing conviction that they were guilty, that they would let these men free today?
It was 1993. No. The 3 second graders are found drowned in a ditch in West Memphis. It was before Arkansas could handle DNA testing, no physical evidence to link the teens to the crime.
They were the unusual kids in town, dressed in black. They listened to heavy metal music. They were goths before goths were fashionable. And so they were easy targets.
But one of the teenagers, Jesse Miskelly, borderline mentally disabled with a documented low IQ, confessed after 4 hours of police interrogation, implicating his friends. He would later recant, but the town was already convinced the 3 devil-worshipping kids were guilty.
There seemed to be a whole scare in the community around a satanic panic.
I hope y'all really believe in your master, the Satan. He's not going to help you. To me, this place as I stand...
This guy, something Hobbs, Terry Hobbs, right? Isn't that his name? He's the stepdad to one of the boys, and he's so annoying. He was in the Paradise Lost movies. He was so obnoxious. I couldn't stand listening to his voice. And it's potentially possible that he might have had something to do with it, and he was never looked into by law enforcement. Let me play back that.
I believe in your master, the Satan. He's not going to help you. To me, this place as I stand is like hell on earth.
All 3 would go to prison. Damien Echols, called the ringleader, was sentenced to death row, held in solitary confinement for a decade. Johnny Depp became so convinced of Echols' innocence, he gave voice to his prison journal.
I can't remember what...
Held in solitary confinement for a decade. 10 years without human contact. I've been following the Karen Reed case, and they basically had Turtle Boy Aiden Carney, who is a reporter who's been reporting on the case. They put him in jail basically to shut him up, to try, well, they tried, but it didn't work. And he talked about he was basically in solitaire. He was in medical, which was basically solitaire. He only got like 1 hour of exercise and then 1 hour rec or whatever, and then back to his cell, and never interacted with people except for the people that brought him food. And he said it was the most lonely, isolating thing. And that's where Richard Allen is right now in the Delphi case. And it's no joke, man. It's scary. Anyways, let's continue.
It's like to walk as a human being anymore.
Then, finally, new hope. New attorneys forced the state to perform DNA tests not available in 1993 on hair from the victims. The findings are dramatic. None of it is a match to the imprisoned West Memphis 3. And in fact, the DNA points in a different direction.
I don't think they would have let them walk.
The DNA points in a different direction? I'm sorry? So they had some hairs tested, and none of the boys, all of the boys were excluded from that hair. But who wasn't excluded from the hair? They're not telling us that. I think they know who did it. And it'll never be tried again, I don't think.
Walk free if they didn't understand that this would be a very powerful defense. Because not only would the prosecutors have a very difficult time linking these three to the crime, the defense could very legitimately point to someone else, someone specific, and say it's more likely that he did it than my clients.
Which brings us to today, in one of the most shocking and even confusing exonerations seen in a U.S. courtroom. The West Memphis 3 would be allowed to walk out of prison, but prosecutors agreed to sign off on the deal only if the defendants would plead guilty.
Guilty plea today? Guilty. I am pleading guilty.
Normally a judge will say,
this is the Alford plea, that you admit you're guilty even though you say you're innocent, and but you admit that they have enough evidence to say that you're guilty, to call you guilty. So you take the deal and you get to go home, or you can stay in prison and you can enjoy your execution.
You can plead guilty, but you need to tell me what you did. You need to say that you did it. This is different.
This is totally different. I mean, this is the defendant saying, almost with a wink and a nod, yeah, well, plead guilty, in quotes. But the reality is, they're saying, we didn't do it.
It's not perfect. It's not perfect by any means, but we can still try to clear our names. The only difference is now we can do it from the outside instead of having to sit in prison and do it.
In fact, it was a deal the youngest of the West Memphis 3 first resisted, wanting to fight for total exoneration, until reminded that his childhood friend Damien Echols had been in solitary confinement for 10 years, and at one point was 3 weeks from execution back in 1994.
He didn't want to take this deal in the beginning, and I recognize and acknowledge that he did do it almost entirely for me. Thank you.
For Nightline, Jim Avila, ABC News, New York.
Oh, that case makes me so mad. They obviously did not get the right people. So we're going to, like I said, we're going to read now the brief, now that you know a little bit more about the background. I didn't want to leave you, with nothing if you didn't really know a whole lot. So anyway, so this is Damien Echols versus the state of Arkansas. Isn't that kind of interesting to see, instead of state of Arkansas versus so-and-so? It's kind of nice to see it on the other end. I don't know. All right, so we've got Honorable Tanya Alexander, Circuit Judge, and J. William Manuel Bartholomew J. Kempf. Are those the two different people? I think so. Those are two appellate attorneys and another attorney over here, and someone from the Innocence Project, or a couple people from the Innocence Project. So we've got quite a few people writing this, and this is an amicus curiae, I should say. So amicus curiae is kind of like, so Echols already has his whatever portion that he's submitted to the Supreme Court to say, this is why you guys should allow me access to DNA testing so that I can clear my name. So he's already submitted that. This is a brief in support of his request, and it's it can basically just come out of nowhere from like an ACLU or an Innocence Project or whoever, because just recently with the buffer zone around the Commonwealth Courthouse in Massachusetts during the Karen Reed case, all the protesters have been booted 200 feet with a buffer zone. So people appealed at that, and the ACLU came forward with an amicus brief saying, like, here's a whole bunch of reasons why you should allow this to come in. And Bev Canoni rejected it anyways, but yeah. There's some crookedness and some cover-ups going on. Crooked Canton is what I should have called my series. Crooked Copville Canton. All right, so we're going to go right to our statement here. So jurisdictional statement. This appeal arises from an order entered by the Circuit Court of Crittenden County, which dismissed Echols' petition for lack of jurisdiction. Echols timely appealed. Echols was sentenced to the DP at his 1994 trial, and this court has heard prior appeals to this case, so this court has jurisdiction. Introduction and summary of argument. Some 2 decades ago, the court recognized in a case involving appellant Damien Echols that Act 1780 addressed nationwide concerns that innocent persons were being imprisoned and even executed for crimes that they did not commit, and passed in order to accommodate the advent of new technologies enhancing the ability to analyze scientific evidence. Echols versus State. The General Assembly created procedures to facilitate the exoneration of any innocent person who should establish innocence through previously unavailable scientific evidence. See the case before, recognizing the legislature's belief that the mission of the criminal justice system is to punish the guilty and to exonerate the innocent. So it is the court's responsibility to exonerate people that have been wrongfully convicted. It is their responsibility to not just let it go as law enforcement would, or whoever, prosecutors, whoever's prosecuting it. All right, so nothing suggests that the General Assembly intended that these protections would be available only to innocent persons who are still incarcerated when the exonerating evidence becomes available. So that was one of the big reasons why they denied Echols' request for this DNA testing, was because he was no longer incarcerated. Well, you know what? He still has that guilty all over his record. He is a convict through and through by the eyes of the state and everything that comes with it. I'm sure he cannot vote. It's hard for him to get a job. I imagine. I don't know what they're. This is just Damien. Baldwin and Miss Kelly also have a tarnished reputation, a tarnished character, because of this case, because they were wrongfully convicted. So exonerating them can only be a good thing. If they did not commit the crimes, then, and if we have the technology to prove it, then let's do that. All right. Sorry, I get into tangents because I get mad. I just find this stuff, I'm passionate about it. I find it really interesting. All right, so nothing suggests that the General Assembly intended that the protections would be available only to innocent persons who are still incarcerated when the exonerating evidence becomes available. Quite the opposite. Actually, the Act's preamble describes dual procedural protections that would provide 1, methods for preserving DNA and other scientific evidence, and 2, a remedy for innocent persons who may be exonerated by this evidence. Right there, Judge. Right there. We'll highlight that. A remedy for innocent people who may be exonerated by evidence. All right, so the first purpose necessarily contemplates needing to preserve DNA and other scientific evidence until science advances enough for it to be tested. There is no time limit. That makes sense. To fulfill the second purpose, evidence must remain available to that so that any innocent person may use it to establish factual innocence. Allowing proof of timeliness by establishing that the new method of technology that is substantially more probative than prior testing is available. The Act's preamble proved prescient. Prescient? What is that word? I know I've seen it before, but am I saying it right? Prescient? Prescient? Let's stop making a fool of yourself, Heather, and look it up. I like to learn words. All right, so here's
prescient.
Sorry, that was loud.
Prescient. Prescient.
Prescient. Having or showing knowledge of events before they take place. A prescient warning. So where were we? The preamble proved prescient. DNA testing and extraction technology has evolved significantly since then. With each development, law enforcement identifies more perpetrators and more wrongfully convicted individuals are exonerated. Echols' petition to use the most recent advance in DNA extraction technology, the MVAC wet vacuum-based collection method, to test ligatures that the assailant used to bind the victims, which have never been successfully tested. The MVAC technology can extract DNA from porous material like those ligatures, which I believe were their own shoelaces, were they not? I really want to say that they were shoelaces, was what they were tied with. Their own shoelaces. Which, all right, so the MVAC technology can extract DNA from porous material like those ligatures, which enables law enforcement to identify perpetrator DNA that went undetected by prior testing methods. For just one illustration of MVAC's superior abilities, it was recently used to solve the 1979 unaliving of a 12-year-old girl in Texas by retrieving DNA from clothing years after swabbing proved unsuccessful, and with the recovered profile matched to a known offender's DNA. Let's take a look at that footnote. Michelle Taylor, MVAX, helped solve 1979 unaliving of 12-year-old girl. Interesting. There's a video. All right. Forgot where it was. MVAC collection likewise could retrieve key DNA evidence that could exonerate Echols and identify the real perpetrator of who took the lives of those 3 young boys and assaulted them and tied them up with their own shoes, and I don't know. That was not good stuff. Not good stuff. All right, so even beyond the Act's preamble, the codified text confirms that the procedures apply to anyone who can prove their innocence through new scientific evidence, regardless of incarceration status. Sections whatever provide several forms of relief that are unrelated to incarceration. First, as Echols did here, a person convicted of a crime may move for the performance of scientific testing to establish innocence if certain enumerated criteria are met. And that's according to some Arkansas code. Incarceration is not one of the criteria. If previously unavailable scientific evidence establishes innocence, the person may commence a proceeding to secure relief by petitioning the circuit court to vacate and set aside the judgment and to discharge the petitioner or to resentence the petitioner or grant a new trial or correct the sentence or make other dispositions as may be appropriate. So a person who is incarcerated might ask to be discharged, while another who is not incarcerated might ask the court to vacate and set aside the judgment and make other disposition as may be appropriate. The point of allowing later DNA testing is to provide innocent people a legal framework, one, for accessing ever-changing scientific developments. Just because they got out of prison in whatever year doesn't mean that they're exclusively limited to scientific testing from then and prior. That's not what I mean, they should still be able to get a chance to exonerate themselves. It's ridiculous. All right, so number one, for accessing ever-changing scientific developments, and number two, to be able to walk truly free, untethered to any vestige of their wrongful convictions. Like I said, can't vote. You probably, can you move? I mean, can you move without, like, if you're a convict? Can you move without telling the state? Like, don't you have to tell the state? If you, I have no idea. I'm sure there are limitations on convicts who are now free, but have a tarnished record, and I'm sure there's many limitations that I am not aware of. I kind of want to look into this now because I can't think of a ton off the top of my head, but there's got to be some. Yeah. Anyways, getting a job and just having everybody think that you're guilty of something, such a heinous crime. Anyways, all right, so let's keep going. The circuit court denied relief because the act was codified in the habeas portion of the code, but assumed that Act 1780 offers only habeas type relief. Not so, it provides several protections that are not traditional habeas relief. Let's just define habeas, or habeas relief. A habeas corpus is a writ requiring a person under arrest to be brought before a judge or into court, especially to secure the person's release unless lawful grounds are shown for their detention. So habeas, what is habeas relief then? That was habeas corpus. The right of a citizen to obtain a writ of habeas corpus as a protection against illegal imprisonment. Okay, so that's what that is. So it provides special or several protections that are not traditional habeas relief, affording the procedural protections of the act to wrongfully convicted but no longer incarcerated innocent people like Echols is consistent with other states' laws. Act 1780 is modeled after an Illinois law, Illinois shout out, that courts have interrupted to not require incarceration. This court should continue to follow Illinois case law as an interpretive framework. Go Illinois, being progressive and all that. All right, so argument. Denying relief to wrongfully convicted persons who already have been released from custody would frustrate the Act's express purposes. The Act's dual purpose necessarily assumes that DNA and scientific evidence might only become available years after a conviction or even after a person's release. The evidence preservation requirement and access to testing together aim to allow any innocent person to access testing that could lead to their exoneration. Imposing an incarceration requirement would preclude countless wrongfully convicted persons from accessing relief, including those it would most likely benefit. A. DNA technology continues to evolve, enabling testing to identify perpetrator DNA from items that previously could not be successfully tested. DNA technology has advanced significantly since its inception. Watershed developments in testing, extraction, and profile interpretation have made it possible to obtain conclusive results, exclude wrongfully convicted persons, and identify actual assailants where previous technology could not. Law enforcement now okay, so this brief was not authored in whole or in part by counsel for a party, and no counsel for a party made a monetary contribution intended to fund the preparation or submission. So they did this willingly and on their own, the Innocence Project, in support of Echols. So that says something. Like, we weren't paid to do this. We took our own time. You know, this was our own time that we did this because we believe in this strongly. So law enforcement now routinely reviews unsolved cases to evaluate whether new technology would help identify the perpetrator. DNA access statutes like Act 1780 were passed to harness scientific developments and explicitly provide for testing, even when testing was previously conducted, if newer technology could provide more probative results. Number one, the rapid evolution of DNA technology. I mean, that's a huge given that, you know, what we have now versus what they had in 93 is totally different. To illustrate, when DNA was first used in criminal cases in the late 1980s and early 90s, forensic scientists primarily used the restriction fragment length. The what? The restriction fragment length polymorphism. The RELF test. Say that 10 times fast. It was highly discriminating, i.e., it could narrow down the likelihood of a match in the population. See John M. Butler, Fundamentals of Forensic DNA Testing. But it was not very scientific, i.e., a large amount of undegraded and unmixed DNA was needed to produce a DNA file. See whatever this article is, that's the source they're citing. So, although revolutionary, that limitation made the method like, why do you even do the RFLP? The RFLP method, often useless in practice. Next was polymerase reaction, whatever, PCR, and I don't care how you say it, but it had the opposite flaw. PCR testing enabled the amplification of small amounts of DNA. See Robin Thomas et al. An overview of DNA typing methods for human identification, past, present, and future in DNA electrophoresis. You can read the rest. All right. But it was not highly discriminating. See Butler at 67. Typically go only to 1 to 1,000 people. This level of DNA testing can be attributed to like 1 in 1,000. So it's still not as exclusive what they're talking about here. This polymerase chain reaction. In the mid-90s, scientists developed short-term repeat, or STR, which you've probably heard if you've been paying at all attention to the Idaho 4 case, and the STR and the STP or whatever, I don't know, whatever there are. There's a couple different ways. And the STR is the most used, I guess we would say. The most typical up until maybe even now. I don't know. All right, so in the mid-1990s, scientists developed short-term repeat STR testing, which finally enabled identification of profiles from smaller samples while also providing highly discriminating results. This quickly became the gold standard, and partly because STR was such a significant development, in 2004, Echols was granted STR testing under Act 1780 on the victim's pants and other items of clothing. See generally Echols versus State. That testing excluded Echols and the other two men convicted of the unalivings, which led to the parties negotiating an Alford plea. So it excluded them, but they still had to plead guilty to get out of prison. Don't ask me. I don't know. And the three men were released. Okay. But the results did not conclusively identify the perpetrators. And therein lies the problem, I guess, because you can't put it on someone else. Now you've got to save face as a state too, you know, as the law enforcement and the prosecution side, you want to save face and say, well, we still could have put you away, but all right, since you're excluded from this testing, we'll let you out, but you got to plead guilty. Like, what kind of backhanded, corrupt kind of shit is that? But the results did not conclusively identify the perpetrator. Since then, Echols has continued to maintain his innocence and the ability of new DNA testing methods to yield discernible, identifiable genetic profiles from crime scene evidence has continued to improve, grow, and evolve. So only time has gone by now since the last testing, which got them off on the Alford plea, which was when? 2004. After being in prison for 10 years. Right? If the 94, 2004. All right, so all right, we're moving on. Number 2. Advancement in technology leads to increasing utility of DNA databases. Like with Echols, exoneration sometimes depends on identifying the source of crime scene evidence. Not just excluding a convicted person, but matching crime scene evidence may not be possible, until the assailant's DNA is obtained. So they might not have had the perpetrator's DNA in their CODIS system up until now, but it's now 20 years later. It might be. They might have the actual perp in CODIS or in their DNA, in some searchable database. It could be there by now. Because a crime like that, they probably have a record. I'm just gonna say. For other things, but I don't know. But it's not their only crime. So the development of highly discriminating and sensitive DNA testing has fostered the creation of a powerful tool, searchable DNA databases, which I was just talking about, maintained by local, state, and federal authorities. This has radically increased the probative value of DNA testing in criminal cases. Previously, crime scene samples could only be compared to a DNA sample collected by law enforcement from a suspect. Now, unknown DNA profiles can be uploaded to the FBI's national database, the National DNA Index, or NDIS, which can, or NIDS, which can then be matched as a known individual or evidence from another unsolved crime with using the FBI's CODIS system. See that link for more. All right, so this process has unlocked the ability to solve cold cases and to identify the true perpetrators in wrongful conviction cases. Thanks in part to statutes like Act 1780, many jurisdictions now retain DNA samples for future comparison if later developed technology is able to provide new evidence that can provide new answers. These databases have grown exponentially as testing capabilities have advanced. Each piece of evidence that is tested or retested with new capabilities like the MVAC collection method could add DNA profiles to those databases and aid in countless investigations. So this new MVAC collection, like, it can extract I think it can extract DNA from the air. Let's look. I don't want to give you the wrong information. MVAC DNA. It's a wet vacuum based, I lost my place. Hold on. Alright, the dog needs her spot. Alright, so forensics DNA collection helping investigators solve more crimes. Slammed into my desk. I need my charger. Sorry, I was on the floor. All right, so sometimes DNA evidence is on a difficult item to collect. It may be porous, rough, or large. In addition, the quantities may be minute. Real-life scenarios like that happen every day. In 2011, Jutta von Swedler was unalived in her own house and was found in her bathtub. The investigation of the scene yielded a number of pieces of evidence, including a pillowcase and comforter. Traditional sampling of the crime scene evidence yielded inconclusive results. The MVAC was used to collect from the pillowcase and the comforter. The collections yielded DNA profiles that matched the convicted unaliver's profile. An internal and independent evaluation of the MVAC has been conducted by the FBI. Their findings from sampling 22 different substrates are very interesting and were published in the summer of 2020. The technology provides a new opportunity to get profiles where it was impossible before. Whoops. My little cloth here, I have my light is so bright sometimes I gotta cover it because it blinds me. Alright, so the technology provides a new opportunity to get profiles where it was impossible before. Yeah, so this MVAC thing is scary because it could get DNA of people, like this minute DNA that's like a touch DNA that's been passed on from person to person and onto another object, and then you're still convicting the wrong person potentially. So I have my issues with the MVAC collection too, because how if we're just going to pick up minute pieces of DNA that are all over the place, all over the world, like we're going to be really searching. I don't know. I mean, it's possible someone else laundered the sheets. They were from the factory, packed in the, straight out of the pack from the faculty. Who knows? Or factory, not faculty. I'm losing my faculties. So, yeah. I think you know what I mean. All right. So each piece of evidence that was tested or retested With the new capabilities like the MVAC collection method, it could add DNA profiles to those databases and aid in countless investigations. As of November 2022, NDIS contained more than 20 million profiles, and CODIS had assisted in more than 622,955 investigations. And that has a footnote. Oh, that's just where they got the information. All right, so Arkansas's own database contains more than 179,000 profiles and was aided in almost 7,000 investigations. So, I forget it. The thing keeps falling. All right, so yeah. Of the 375 DNA exonerations nationally, CODIS was used to discover the actual assailant in nearly half of them. So that's pretty good. I mean, maybe confessions and other things have been more at the forefront than CODIS, but, or testing. Well, no, because I don't know. You gotta, a lot of times you gotta find your like, it's not fair that the defense has to solve the case, whereas, you know, if the prosecution gets it wrong, and that's what they've had to do, I feel like, in order to clear their names. All right. Number 3, additional advances have expanded the evidence that can be tested. So these significant and continuing advancements have also expanded what can be DNA tested, which is now nearly everything. As this case shows, recent advancements with STR testing have made it possible to obtain results where previous testing could not. In 2017, the FBI expanded CODIS to new STR genes, which led to new STR testing kits. Those kits allow for amplification of even smaller portions of DNA, so previously undetected assailant DNA can be identified if evidence is re-examined, but also previously undetected non-assailant DNA can be identified and used to convict the wrong person, in my humble opinion, but I'm going to keep going. The emergence of probabilistic genotyping software has enabled scientists to interpret evidence that contains mixtures of DNA from multiple individuals, and that was previously interpretable. God, I can read. That's our footnote. It's just sources. All right. In my mind, it was another word, and it wasn't sounding out in my head. Or in my tongue, sorry. All right, so new collection methods, such as the MVAC, have enabled the recovery of DNA that could not previously be extracted. Forensic scientists historically have used conventional collection techniques, swabbing, cutting, taping for DNA. This was mostly effective, but not for porous samples, e.g. Cloth, wood, where DNA may be absorbed into the material and not readily obtained on the surface. MVAC is an emerging technology that uses wet vacuum. It is particularly successful in extracting DNA from porous samples like the ligatures here. So in this case, it would be appropriate to test them to see if we find any other DNA besides the boy's DNA. MVAC is even able to extract DNA from samples that have been previously swabbed, so evidence from old cases can be retested where prior collection techniques failed to collect testable DNA, or if you have a very small sample of DNA and you basically destroy all your sample by testing it, maybe you don't have to do that now. Maybe you can take smaller portions of your sample, even smaller portions, and duplicate them. You know what I'm saying? I hope you know what I'm saying. All right, so genetic genealogy also emerged in 2018 as a novel investigative tool for solving cold cases. In cases where DNA has been identified, but a CODIS search failed to help identify the DNA depositor, law enforcement has been able to search consumer-based genealogy databases for individuals who share particularly matching or very similar DNA with an unknown DNA sample. And this is a problem. See, I mean, they're saying like these are good things. And in some cases, they might be. This might be a benefit, but in some cases, it might not be. If you are Brian Koberger and you're sitting in prison, this is a problem. Because if you don't know where the DNA is coming from in the first place, and the law enforcement has been able to search these consumer-based genealogy databases, and we found out in Idaho 4 that they've been doing this illegally and pretty much breaching all of our private rights as citizens by going in and sharing our genealogy results from these databases like 23andMe and whatever. I don't know which ones in particular, so don't quote me on 23andMe. I'm just saying some of those kinds of genealogy companies. So using those leads and traditional genealogy, law enforcement has been able to identify assailant DNA and solve more than 400 cases, including 2 that led to exoneration. Genetic genealogy recently enabled Arkansas law enforcement to solve the 1996 cold case unaliving of a 16-year-old girl. And her name was what? Was it Max Brantley? I don't know. That's the source. Maybe that's not her name. Oh, the suspect took their own life after they found out. Alright, anyways, alright, so on to the rest of the document. The ability to link DNA to a known individual is key. In some exonerations, like the example below, innocence is established by excluding the convicted person and matching the DNA to someone else. Here, Echols already has been excluded, but the new MVAC technology and genetic genealogy advances could finally and conclusively match key evidence to the true perpetrators of these crimes and thereby exonerate him and the other 2 effectively. So the evidence preservation function of Act 1780 is critical. By creating a mechanism to preserve forensic evidence, it allows for these DNA advancements to be applied as they are available, irrespective of time, or if you're incarcerated or not. So it doesn't matter how long it's been since the crime that you committed. There's no statute of limit on testing DNA either, that I know of. So that is critically important in solving cold cases or correcting error in older cases as the science develops. Chris Tapp's case, for example, bears key similarities to Echols. Pretrial DNA testing in Tapp's R and unaliving case excluded him, but CODIS failed to yield a hit. Years later, thanks to the MVAC technology, new evidence emerged, and its testing led to the modification of Tapp's sentence and his release. Later comparison of that DNA evidence to genetic genealogy helped to identify the true perpetrator. Tapp was exonerated, and the true perpetrator was convicted. B. Limiting access to testing would produce absurd and intolerable practical consequences. If Act 1780 applies only to those who remain incarcerated, the utility of DNA advancements would be significantly curtailed. Innocent individuals and their families would be robbed of the opportunity for exoneration simply because they had completed their sentences before the new advancements became available. That would frustrate the Act's purpose, lead to absurd results, and allow true perpetrators to remain free. Yeah, by not testing it, you're allowing the actual person more time of freedom. Widespread downstream consequences are not hard to imagine. For starters, the wrongfully convicted would face the untenable choice between parole and potential exoneration. Holding that a defendant on probation was not in custody. That creates a perverse incentive. Someone's convicted of R, for example, is usually eligible for parole after serving 70% of the sentence. So a wrongfully convicted person sentenced to 10 years and granted parole after 7 would not be entitled to relief because of new DNA evidence that becomes available at any time thereafter. Worse, if the evidence comes to light as the person becomes parole eligible, he would face a choice between parole and potential exoneration. That cannot be what was intended by a remedy for innocent persons who may be exonerated by DNA evidence. The ruling below also would prevent exonerations to illustrate the periodic. You guys can pronounce that word on your own. DNA. To illustrate the DNA case involves SA or R, where assailants were more often leave behind biological and physical evidence that are capable of being tested. R carries a minimum 10 years imprisonment in Arkansas. The timeline of DNA technology's evolution reveals the absurdity of the circuit court's ruling. If an innocent person was wrongfully convicted in 1990 and sentenced to 20 years, he would only have the benefit of DNA testing advancements before 2010, i.e., the incarceration period. Even if current DNA technology, new STR kits, MVEC genotyping, forensic genetic genealogy, made it possible to determine innocence with absolute certainty, there could be no relief. That would be arbitrary and absurd, but it is not hypothetical. In a number of DNA exonerations for R, the wrongfully convicted had already been released when testing became available to establish their innocence. That's interesting. So last month, Tyrone Day, who pleaded guilty in 1990, was exonerated based on new DNA evidence after serving 26 years for an essay he did not commit. 8 years after his release on parole, Texas' highest criminal court vacated his conviction, exonerating him. Marvin Anderson served 15 years for R. Evidence that could only be located and tested after his release not only excluded him, but matched another man in the CODIS database who had confessed to the crime more than a decade before. Wow. Anderson was subsequently pardoned by the Virginia governor. Wow. Eddie Lowery, I think I've done a video on him. Or I might have him on the schedule. I don't know. The name's familiar. Just spin all over myself. Not really. The straw did. Alright, so Eddie Lowery was dishonorably discharged from the U.S. Army after being wrongfully convicted of a 1981 home invasion R in Kansas. Upon release, after 11 years in prison, Lowery was required to register as a offender. In 2002, DNA testing definitively excluded Lowry and his conviction was vacated. Almost a decade later, the CODIS database finally linked the DNA to the true assailant, who has since pled guilty. Those are just the links. All right. So the ruling below would have prevented all of those exonerations and would frustrate the intent of Act 1780. As if to compound those unjust and unreasonable effects, the state now argues that Echols forfeited new testing by entering an Alford plea. This just proves the point. Alford pleas exist to allow a defendant who refuses to admit confession of the criminal act and maintains his innocence, but nonetheless intelligently concludes that his interests require entry of a guilty plea to limit the penalty. Yes, you're forced to plead guilty, even though you still, they've refused to ever admit that they did anything, because they didn't. All right, so for Echols, that meant avoiding the DP. Worse, Echols was offered the Alford plea in part because of DNA test results that he obtained under the Act. This court has never held that an Alford plea waives the right to post-conviction DNA testing. And they cite other cases. What? Alright, so something declining to reach the question, and it should not. Otherwise, the wrongfully convicted would face another Hobson's choice. Submit to an unjust sentence, hoping that DNA testing will advance enough in their lifetime to exonerate them, or secure release by waiving the ability to clear their name and shed the collateral consequences of conviction. That choice is purely a creation of the state's argument. Echols seeks to establish innocence through new MVAC DNA testing technology that was not available until more than 25 years after his sentencing. He should not be denied that testing simply because he has been released. I agree. This case has already shown the importance of Act 1780, and relief should not suddenly be limited when science has finally advanced enough to conclusively establish Echols' innocence, identify the true perpetrators of the crime, and put this case to rest. Any any incarceration requirement ignores both the plain text and the availability of non-habeas relief that the Act provides. The circuit court reasoned that the statute sits within the Code's habeas section, and habeas addresses only wrongful incarceration. That ruling conflicts with the plain text and meaning of the Act and the numerous non-habeas forms of relief that it provides. Oh, this was an actual footnote. Even beyond imprisonment, a conviction carries significant additional post-release consequences, not to mention the lasting stigma that a conviction can leave on the family of the convicted. So there you have it. I mean, more of a reason why it's very important to exonerate when we can. A. The circuit court ignored the plain meaning. Nothing in the text conditions relief or incarceration. So there's nothing in the rule that says you have to be incarcerated to get this relief. Just the opposite, actually. Act 1780 is available to any person convicted of a crime without limitation. Echols fits that definition, and the statute expressly provides for several forms of relief that are not related to incarceration. Petitioner may move to vacate and set aside the judgment, and 1. To discharge the petitioner, or 2. To resentence the petitioner, or 3. Grant a new trial, or 4. Correct the sentence, or 5. Make other disposition as may be appropriate. The circuit court ignored the statutory differences between traditional habeas and a motion for post-conviction testing. Act 1780 provides relief that is plainly unavailable via any other habeas petition. Arkansas law provides forms of relief for a petitioner who is 1. Detained without lawful authority, 2. Imprisoned despite being entitled to bail, or 3. Actually innocent. The first two are governed by section whatever, traditional habeas. Innocence claims are governed by same section, 16-112, 201. Oh, 201. The other one is 101. And the state's post-conviction DNA testing statute. The distinctions between those forms of relief expose the impossibility of interpreting Act 1780 as a habeas statute. First, the statute language, or the statutory language, shows the difference on its face. Relief from unlawful detention necessarily requires incarceration. It is the very relief that the petitioner seeks. Actual innocence claims are not so limited. Second, the relief sought by a motion for post-conviction testing is unavailable under traditional habeas. Section 202 allows a petitioner to seek scientific testing to establish innocence. That is not a traditional habeas relief, i.e., habeas examines the legality of a conviction, and actual innocence is not a grounds for habeas relief. So, yeah, actual innocence. Third, the form required of petition evidence, the form required of petitions evidences the distinction. Post-conviction testing motions are captioned Petitioner versus State of Arkansas because the requested relief DNA testing can only be provided by the state. A traditional habeas petition instead must be directed to the person in whose custody the prisoner is detained, because only the person who detains the prisoner can return him to court. That is usually the director of the Arkansas Department of Corrections. Finally, the procedures differ for each. Section 103 is available to any person who shall apply for the writ by petition showing probable cause to believe he or she is detained without lawful authority, is imprisoned when by law he or she is entitled to bail, or who has alleged actual innocence of the offense or offenses for which the person was convicted. For individuals detained or imprisoned, their petitions are governed by the procedures in section 16-12-101, 112-101. But the procedures for persons who allege actual innocence shall be in accordance with this other statute, an entirely different code section. Whatever. Okay, that was confusing. The General Assembly recognized the inherent differences between habeas and motions for conviction and post-conviction testing. It created different requirements, forms of relief, and procedures for each. The Circuit Court did not attempt to fit this case into the distinct habeas framework, but instead borrowed only one requirement and inappropriately imposed it wholesale. This court should rectify this message. Arkansas joined all 50 states in recognizing the importance of access to new scientific testing to exonerate the wrongfully convicted, but the decision below threatens that progress. The General Assembly passed Act 1780 in 2001 as part of the nationwide acknowledgement of and response to concerns that innocent persons were being imprisoned and even executed for crimes that they did not commit. Yes, it's still going on. It's still happening. We still have people in prison for crimes we know they didn't commit. All right, it was not writing on a blank slate. New York and Illinois first passed post-conviction testing laws, and every other state followed. But to be clear, the decision below would isolate Arkansas as the only state where an innocent person must remain incarcerated to prove his innocence through new DNA testing, where the post-conviction testing statute does not explicitly require incarceration. Some states followed the New York model, which requires a higher standard of a reasonable probability than the verdict would be more favorable with the new evidence. Arkansas and others followed Illinois with its more permissive standard, requiring only that the result would have the scientific potential to produce new, non-cumulative evidence materially relevant to the defendant's assertion of actual innocence. The court has followed Illinois case law when interpreting Arkansas statute, finding pervasive Illinois courts' interpretation of material relevant. The court should do the same here. Like Act 1780, Illinois' law does not contain language limiting its availability to incarcerated defendants. People versus Schultz. Instead, any defendant may make a motion before the trial court that entered the judgment of conviction in his or her case for the performance. The state of Illinois attempted to argue, like the state here, that the statute applied only during incarceration, but the Illinois Court of Appeals disagreed. Like here, the state argued that the statute's caption indicated legislative intent to limit relief to the term of incarceration. The state argued to the court to interpret the phrase actual innocence in the statute's caption according to its usage in People versus Washington, which tied actual innocence to a deprivation of liberty. Okay. I think we kind of get the point here. Let's move on to the conclusion. The Act's plain language provides the best means of fulfilling its purpose to provide a remedy for innocent persons who may be exonerated by later discovered DNA evidence. DNA technology has advanced significantly since its passage, with more advances to come. In this case, perfectly captures how the Act should work. Years after Echols' conviction, scientific advancements have begun to prove answers in the case, begging for them. It is beyond dispute that the testing Echols seeks is capable of identifying perpetrator DNA, excluding him from being that person, and or identifying the actual assailant. The circuit court's extra-textual interpretation would preclude using the most recent advancement to bring justice to Echols and the victims. So by bringing justice to the wrongfully convicted, you can bring justice to the little boys who lost their lives and who the crime is actually about. But now we've got two sets of victims. We have the victims who the crime is about, the little boys, and now we have the teenage boys who went to prison for years with for a crime that they didn't commit and were coerced into confessions. At least one of them was, anyways. All right, so the court should interpret Act 1780 according to its plain language and ensure that its purpose is fulfilled. Signed, J. William Manuel. And that is that it? That's it. That's the amicus brief. I wish I had the actual Echols versus state documents, because that might be really interesting too. But we're going to get into in another stream, so be sure that you have the notification bell on if you're interested in this topic, because I'm going to definitely do more on this case when I have time to do a deep dive on it. This is one I really want to do a deep dive on if I can, and look through more and more of these court documents and proceedings and what actually occurred, because it's crazy. So let me know what you think in the comments below. Please be sure to like this video, comment, subscribe, all the good YouTube-y things, and I will see you in the next one. Thank you so much for watching. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.